Good to see Eric Wanga. I believe this is somebody I know. We met at some point. Welcome, all of you. Welcome. You can always put in where you're logging in from, your name, what you do, where you're logging in from. We are happy to have all of you. Thank you very much, Caroline. Brian, the floor is yours.
All right, so let me share my screen so that I make a presentation on invisible assets, essentially intangible assets. I know that in one way or another we have interacted with different aspects of this topic that we will discuss today. And of course, as you have been told, my name is Brian Otieno, an advocate of the High Court of Kenya, practicing as a commercial and corporate lawyer with a passion for finance. I also do tax. I enjoyed your presentation previously that was talking about taxation. So I wouldn't want to spend a lot of time. I just want to go straight into the presentation. And just to recap, I remember the last time my Benson Odiwuor Otieno. Benson shared about intangible assets in terms of what they are, how to identify them. And I remember he spoke about various forms of intellectual property rights, which include patents, utility models, trademarks, copyrights. It also includes things like industrial designs, domain names, and such like. And of course, the take home from that session, if I recall correctly, was that we have a lot of potential in the intellectual property space because most of the intangible assets are untapped. They're not used for what they ought to be used for. And I think today we will talk about an interesting angle, which is how to utilize intangible assets for purposes of financing. And as you can see from my screen, I have projected an act called the Movable Property Security Rights Act 2017, which came at a very interesting point. And as you will see from the next slide, that for the first time we had banking and financial institutions giving loans. So for the first time, we now see that financial institutions have been open to issuing loans to SMEs and individuals in business using movable property. You see, we now use, sometimes we saw, by the article, you can see cows were used as security, TV stocks, so receivables, for example. And this is basically because we enacted a regime that enabled us to use movable assets, which include intellectual property rights, as security for obtaining financing from financial institutions. So I will briefly just cover a security right, what it means, security agreement, how we can create, perfect or register and enforce such rights, registration, the registry's collateral, the collateral registry, I mean, and how to identify the role of the legal practitioner in this regime. So I think I'll begin by talking about an interesting story. I know all of us must have grown up during the days when Nakumatt was a big retail outlet. And maybe could be some of us here were employees or beneficiaries of that retail outlet. And it turns out that at some point it faced financial challenges. Now, we did not have the MPSR regime then, but Nakumatt was among the largest holders of trade names and trademarks. It had so many brand names that were registered in Kenya in the Industrial Property Registry, KIPI Registry, and the Industrial Property Institute Registry. And we also had CPIT, that is the Center for Intellectual Property Rights at Stockholm University. So it had a lot of IPRs, or invisible assets, that were possible to use for purposes of securitization so that they obtain financing. But I think because of the lack of the framework that we now have, Nakumatt was not able to use those assets as security or collateral to obtain financing. And I think that is one of the reasons why our parliament moved with speed to try and enact the current MPSR regime. Now, MPSR means what I said earlier, movable property security rights. So MPSR was then enacted to try and solve that problem and allow entities and institutions and individuals to obtain financing by using intellectual property rights to obtain financing. So what I have seen in practice, and I think now it's becoming a common practice, that financial institutions are now open to advancing facilities to people who hold intellectual property rights in exchange for financing. And of course, you need to demonstrate certain things. I see, so the times when we do this kind of transactions, you will be you normally prepare charges and debentures. So sometimes if you're an institution, you need to prove that you have a record that can be demonstrated by financial records, maybe bank statements, that can be shown by, for example, your dealings in terms of contracts you have with people. So, for example, to make it more practical, if you are an author of books, we can see, for example, that you have sales that you have done previously, and you have a given amount of stock, or you command a particular sector of the market, a percentage that can give comfort to the financier that if they advance you loans to roll out your books and sell them, then chances are that you will get money to pay the loan. So in that case, for example, the financier may require that you do an account charge. So you give them a charge over the accounts of your business so that they are able to comfort themselves that in the event of default, then they will attach your accounts and use it as a means to recover the amount that's advanced. I've also seen cases where we do debentures for large institutions, just to pledge, we pledge, the assets of the company, stuff like that. Or we can also do, share pledges. If you're an entity that has shares and you're a shareholder in a business, you can pledge your shares and say, I give my shares as a pledge for purposes of securing the facility, so that if in the event of anything, then you can use that. Now, these are all possibilities that can come if we have, awareness that they exist. The problem that we're now facing, and I think that we have been dealing with now, is that people are still in that old regime where we think that it is only real estate property that can be used as a security to obtain financing. And so we still get stuck that if you don't have real estate property, then we cannot raise capital for the company. But I think, SMEs, as you know, most of them don't have real property. And so it becomes a real challenge, for SMEs to be able to raise financing. Until, of course, we had the 2017 MPSR Act, which repealed a number of legislations that were then used previously. For example, the Hire Purchase Act, the Stamp Duty Act. All these were regimes that were, fragmented in terms of everything was split in a specific statute. So there are so many laws that sometimes you could get lost on which one should I use now and which one should I not use. So this act came and consolidated all those acts, and of course borrowed from some of the precedents in the English regime to set up, one common legal regime that addresses the issues that now faced our country. And so I just like us to go straight into what is a movable property. So it could be chattel, that chattel now in things like justice in action, personal property, all that. Now it could be tangible. Tangible, that is now general. But I think today we are talking about the intangible assets. That is the intellectual property. And basically, as I have looked at it, and as I have explained, some of the objectives of the NPSR Act was to promote consistency, certainty in securing financing when you use IP rights, and also to enable individuals to access credit using, IP rights. So, and of course, we know this. We spoke about authors, musicians, right now, because of the digital era, we have various platforms that can enable artists to generate financing. So we have, for example, YouTube, those who are hitting millions of views on YouTube. So if you have an institution under which that asset is held, then you can be able to pledge, because based on your goodwill and market reach, if you have 10 million subscribers, who we are sure will get to view your music, then if you go to an institution and show that based on the past experiences, maybe previous renditions you've issued of your music, you have reached a particular target and you've raised a particular amount of money from those platforms, and of course performances and invitations and deals maybe with commercial entities and advertisers, then they can be able to get comfort that there's a likelihood that your production, your art, your music can be able to generate some, considerable amount of money to help you service the loan. So because of that, then we have seen cases where, because of the demonstration of ability, financial institutions are now open to using, IP rights, as you can see, purposes of obtaining financing. So I may just want to pause for a moment now and ask maybe if we could have reactions or feedback from any person in the audience. You can chat or you can raise your hand, and if the host gets sight of any, just alert me, and then I will let the person speak. But now we have certain challenges, of course, because most of the IP rights that we have are not having, like, for example, specific value attached to them. And most of the times, IP rights, we gain from IP rights through payment of royalties, for example. So if you have copyrights, if you have, licenses, such kind of things are only monetizable through royalties that can be one-time payments, or we can have a percentage proceeds where we say the value of the asset is maybe 1 million shillings, but we would like to say we can't pay you until we go to the market. Once we get the money and the proceeds from our investment or commercialization, then we can probably split the proceeds on a 50-50 basis, 60-40 basis, 70-30 basis. And I think this, of course, comes also because of the uncertainty in the nature of returns that come from IP rights. You may have, very good music, but it may not recoup as much. So some of those things could be, or we could say for a given period, because music sometimes we have things like hit music. It comes for a season. So we could say that for a certain period that the music is published, then we can have higher returns. But as time goes by, of course, the influence waves and other music would normally come up to challenge the dominance of a particular artist. And because of that, we've seen different, kinds of payments. For books, for example, we could have regular installments, where we say monthly proceeds from the sale of books was X amount of shillings. So we will then share with you a regular installment of this based on the proceeds you get from the business. Now, this payment or rights of payments can also be assigned, to the creators. They can be assigned by the creator to someone else, But also remember that the same way you can assign it to someone else, you can also use it as a security for obtaining financing. So I will now go into the specific ways. When it comes to securitization and finance, we must always talk about three things. We must always talk about how to create the security right. And then we must also talk about how to perfect the security right, that is registration. And three, we must talk about enforcement in the sense of how then do I realize the rights that we have created and registered. So the first point, or the first way of creation is that we will always have written agreements between a grantor and secured creditor. So this is what we define under the Act, under the NPSR Act in your free time. You could look at it. It's called a security agreement. So a security agreement basically is, an agreement that outlines the terms of engagement between you, the grantor. Now, the grantor is the person who is either owning or using the IP right as a security for obtaining financing from the secured creditor or from the lender. So the Act doesn't have a prescribed format for how security rights ought to be, and that then means that you have the flexibility, to determine the terms that will go into the security agreement, and essentially let you have the freedom to contract between yourself as the grantor or the user of the IP rights and the lender or the secured creditor. Now, we could also have cases where we use licenses. So licenses is where you assign not assign, but give someone else limited rights over your IP right, for a particular period of time in exchange for, payments like royalties and stuff like that. So of course, you could retain the right to grant the IP to the lender, and of course now the revenue that you receive from the intellectual property, you can use it, to secure the loans that you may need for purposes of expansion of business, for purposes of establishing an entity, and such like. Of course, there's still a lot to be done when it comes to establishing the framework for IP rights, because we don't have as established markets for IP as in the developed nations. We still have challenges when it comes to evaluation of IP. They are not very standard practices. There are methods that we could use, but they are different methods. And sometimes you see various methods of evaluation being used, leading to an uniform valuation. And of course, there are not so many. Not so many people like to value their IP rights up until, for example, the taxman comes knocking. That is when they are forced to value their IP rights. So as I have explained, a guarantor is a person who creates the security rights, or it could be someone who buys or obtains license from the owner of the IP right and uses it to obtain, some money or business, or uses it, as a commercial tool to gain from it. Now, this, of course, is different from what you normally know as a guarantor. Those are different. A guarantor is someone who you grant the right over the IP right, over the IP asset to someone else. And then, of course, secured creditor is the lender, the person who actually gives the rights. So I've explained this security agreement, security right. And I think I will now go to the next aspect. Of course, I told you about creation, perfection, and enforcement of security right. So creation is where we enter into the security agreement. Now, perfection is now the formalities of registration, because sometimes, if you have an informal agreement, it may not be easy to enforce because there is need to be proof that there's an agreement that actually existed. So sometimes, and most of the times, we advise that after entering into the security agreement, maybe with the financier and with your licensees and assignors, those people who want the right assigned to them, you should go to the next step of informing third parties, that you have a right over that asset, so that no one else also has a claim for the same asset. And also that if anyone wants to have a claim, then they should be subject to the rights that you have. And that is what we call, so you do that by registering. So right now we have a registry, a collateral registry, where you can register your IP rights, by issuing what we call, a notice. So of course, there are three types of notices. We have the initial notice, then we have amendment notice, and a withdrawal notice. So the initial notice is where now you have an initial agreement with, an institution or someone wants to finance you, and it's basically notifying or the public and everyone else by way of registration that you have a security interest of an IP right, so that if anyone else comes subsequent to yours, then as we always say that the first in time takes precedence or priority. So that if you register your IP right before anyone else comes, and someone also lays claim to the same asset, then the person whose registration came first will have the rights over the asset. So anyone who comes after that, then the rights will be limited to the person who had the first registration in time. And then, of course, now enforcement comes with the aspect of how do you recover your loan, and how do you realize. So sometimes you could use leases, you could use sale, or all those kind of things. Of course, in the event that there's a default or if that agreement specifies that the enforcement will be based on particular conditions. So if, for example, you don't meet particular payment targets, or you don't do particular things that the agreement outlines, then the person who the secured creditor or the lender could then go the next step of enforcing the right under the agreement, by selling the IP rights or by leasing or using various methods to realize the IP rights. Now, I think we'll now go over this very briefly. I think I have covered quite a bit of it. And of course, as you say, that the agreement always should be in writing so that you have proof and you have evidence for future reference that you actually had an agreement that is entered into between yourself, maybe as the owner of the IP right, and the lender or the creditor. Now, of course, I also mentioned earlier that most of the times, as you've seen in practice, we have, receivables as the major linkage, so that we need to demonstrate to the financial institution that we have the ability to generate financing, because any person investing in your IP rights should be having the comfort that there's a high likelihood that you can recoup the benefits from your IP rights, and also that there's a likelihood or possibility that the potential of your assets can generate returns. So from there, then we can charge your receivables, we can charge your accounts, and use them as security for obtaining financing. Now, when it comes to registration of notices, and this is what we call perfection, we now have a system. It's now done online through an e-registry. We could say Citizen or on the business registration service, which is called BRS in short, Business Registration Service. And it allows you from wherever you are to do your registration of your IP rights and your collateral agreements. And it's done, online, time-stamped, real time. And anyone who then wants to enter into an agreement over the same assets, if he does a search, he can be able to see that there is already an existing agreement over the same assets. And so that then becomes an issue. If they want to go forward, then they know that their rights are diminished or limited to the first person who registered, so that if there's an issue and we dispose the asset, the person who will be paid first is the person who registered first in time, so that the person who comes after or subsequently will only be paid in as far as there's a balance that remains from the registration of the first person. So that should sink in, so that you don't get into agreements that are already held by someone else, and then you end up losing out on your rights or losing out on the returns that you get. So always, as part of the due diligence, try to always check, because it's an online portal that is publicly available. You can easily just find out, do just a search and find out if that asset has already been registered under the Collaterals Registry, and whether it is possible that someone else will lay claim over the same asset if there's a default in payment or such legal issues arise. Now, As I said, priority comes first based on registration. I would not want to repeat that. And this is very legal, so I would not want also to repeat that. Now, enforcement is now the last thing that I want us to speak about, so that I have a point or a time for interactions. So enforcement basically deals with how to recover the rights. So you say that under the agreement, you can be entitled to sue. You can file a claim against someone for enforcing the rights that are under the agreement or under the contract. You can also be allowed to appoint a receiver, someone to help you liquidate. Now this is from the perspective of the lender. If there's a default, then it can be allowed to appoint a receiver that will help you to realize the assets. Right to lien. Under the agreement, if you granted someone rights and they have possession of the right, or they have control of the right, because IP rights you can assign. In that case, then the person to whom it's assigned, the assignee, is the one who basically has rights over it. So they can have lien. Lien is where now they retain it, until you are able to pay the full amount as agreed. Yeah. And they can also lease the same. So they can then use it to realize the amount that they should, then of course for some time, and then it reverts back to you. Or they can decide to sell it, or some can take over the property or take possession. And some of them, as you said, when you charge your accounts receivable, then of course any money that comes into the account based on the business done, then of course priority will go to settling the amount before anything else. So those are the methods of enforcement. And of course, you say that there's some of the things that are not subject to MPSR. And I think this, of course, doesn't apply to IP rights, because IP rights are essentially subject to the MPSR. You can charge them, but there are things like shares that are traded under the NSE, things like aircrafts. Those things are not subject to the Security Rights Act. Now, as I had mentioned, some of the challenges that we're now facing, and I think which are now being addressed, of course, are, we have competition from digital lenders issuing unsecured loans. So the likes of Tala, they come and issue exorbitant loans, issue loans, and they compete, of course, with the mainstream or established institutions. But the problem now is that they don't take securities, which then, of course, limits the space that we can use our IP rights for. Then we have, of course, the issue of we don't have a common point where we can check our IP rights against other rights. We have, KIPI still operates mostly, on a single registration. So they have not linked up the databases to other platforms. So it is possible that you could have an IP right, but then no one could tell whether it is used in securitization, because there's no linkages. You don't have a consolidated platform that allows us to do all this. Sometimes, of course, the people who go on to register notices without conducting searches, and we also have, sometimes there is no standard way of describing, the IP rights. Like when it comes to valuation, for example, different people have different methods, and it may affect the uniformity, of valuation of IP rights in the market. And not so many people also want to do valuation of the assets, as I said, until, of course, an issue arises like a legal issue, the taxman comes knocking and all that stuff. And there could be issue about awareness, which of course needs to be addressed. So I wouldn't want to go further. I think I have exhausted my presentation, and I will just want to stop sharing so that I get to hear from the members of the audience, whether they have any questions, and whether they have also inputs and additions that may be helpful to those who are listening to us today. Otherwise, I thank you for the invitation, and I'm glad that we have been able to tackle this. Yeah.
Thank you. Thank you, Ben. Thank you, Brian, rather. you and Ben. Your names sound similar, eh? Now, there is the first question from Susan. Can I approach Kippy and register a patent, or do I have to engage an intellectual property lawyer? And how complicated is the process?
That yeah, it is possible. It is possible that you could go to Kippy by yourself and do the registration, but I think you require the input of experts because patents basically, require that you meet certain requirements. Novelty, for example, having an inventive step, commercial, reproducible, all those things. So basically, it requires that you have an expert to ascertain that it meets those standards that are set out in law. Before then, you go the next steps of application. And even if you go the next step of application, you need to be aware of the timelines, the 1 year period for application, and also you need to have an expert patent drawer who will help you to draft the sketches and diagrams. So if you have all that, then you could go. But I think if you don't have that, then an expert will be useful to help you in understanding whether you have met the legal obligations and also helping you the patent drawings and the applications and even doing the searches, because for you to be able to ascertain that a patent is new or novel as a requirement of law, you need to do a global search because patents need to be new or novel all across the globe. So if it's something that is available somewhere in India or in US or in UK, then you can't register it here. And if you don't have an expert to help you know that, then it may be easy, or it may not be easy for you to then say that you can register a patent. So it's possible, but it's quite a challenge. And that's why we normally advise that it is good to have experts by your side to help you to see the requirements and also you see whether you meet the qualifications. And of course, the cost may also be quite a limitation because patents, I think, require quite a bit of investment when it comes to application and registration. Yeah. Thank you.
The second part of the question was how complicated is the process?
Yeah, I think I've dealt with a bit of it. It is not straightforward, I could say. Patents, it's the highest form of invention that we have, currently. And that means that when you are registering patents, you must have a high standard. It's higher standard compared to things like utility model certificates and other forms, which is it's quite a rigorous process that requires very extensive examination and searches and stuff. So could be a challenge or could be a very high standard, but it is possible to achieve. Yeah, based on what we've seen, it's possible to deal with and achieve. Yeah.
Thank you. Yes, let's keep putting the questions in the chat. Now, I have a question. Could you maybe one more time just list what are some of those examples of what can be patented? Yeah, can I patent a name of an organization like you are giving Nakumat, and therefore how will it be valued or in a particular way so that we know what it's worth? Yeah, patenting the name KCB or Safaricom or Power Monday. What are some of the things that we can be sure that this one I can patent and therefore it can draw some value for me?
Well, thank you. Good question. Now, I need to draw a distinction, and of course, probably just do a run through on the various types of IP rights that are available. Patents basically are dealing with innovations or inventions that are new, and they're things that are inventive in the sense that it's probably a scientific breakthrough or something that has not been in application before and not ordinarily used by, so for example, an engineer who comes up with a different process or a different way to maybe develop fabrics or make items, it should be something that is, inventive, something that provides an eye opener, a breakthrough for the entire industry. And I think it's always the hardest step to achieve. So patents mostly deals with processes and methods, and it's mostly innovations and inventions. But I think we're talking about when it comes to names, trade names like now, say Power Monday, for example, Live Your Dream, KCB, those trade names now come under what we call trademarks. That is where now you can register a word mark like Live Your Dream, for example. You can register, a symbol like now LYD, what I can see behind you. That symbol, that drawing, it can be a trademark, a combination of the two. Now Live Your Dream and the symbol and the words. That now can become a trademark. So it is possible to register also a trademark, and use it as a mark of your product, so that in the market knows that if I see this kind of Power Monday, for example, I know that it's associated with Live Your Dreams. And so it then gains reputation in the sector, and people trust then your brand, so that from there we can tell that if you launch a product in the market, then because of the market command that you have, or the market percentage that you drive, we are sure that probably the products we produce, if for example you do t-shirts, you produce t-shirts, that are branded Live Your Dream, then we expect that probably those who joined for this call, which were over 60 people, could then take those products and buy them. So I can then go to financial and tell them that I have, this is the market reach, I have this brand, I need financing for reproducing fast moving goods like t-shirts, pens, books, for example, that are branded. And then we tell them that, of course, based on my market share, I expect that this is the amount of money I will gain from the sales. So you can get this amount of loan, and I'll expect that I'll recover this amount of money. So I'll pay you in installments, I'll pay you one-off, depending on the methods we spoke about. Yeah, so there are those two distinctions, but it is possible, yes, to use such things, be able to generate money. Yeah.
Thank you very much. Yes, then we have two questions from Nick, no, three. One is, in case of borrowing from a lender, does the security right have a continuing security provision, or must you create a fresh security right for subsequent loans? And number two is, how long can a lender hold a movable asset, e.g. motor vehicle, as per the Act? And then I don't know whether you want to handle all of them together there. Then the third one is, if I have a business and register a trademark in the trade, is the trade sufficient for me to trade, or must I also register a business name besides the trademark?
Okay, no, let me take them. Let me take them one by one. So the first question is that in case of borrowing from a lender, does the security right have a continuous security provision, or must you create a fresh security right for subsequent loans? Now, as I said, that the Act doesn't have a strict format for establishing a security agreement. Most of the times it depends on negotiation between the parties, and it is open, to the freedom of contracting between the parties. So you may create a continuing security, which of course is favorable to the lender more than the grantor. Sometimes when I'm negotiating such agreements, I do not, if I'm representing the grantor, then I may not want to have a continuing security interest, because that then means that whatever happens, their security right remains for infinity, for infinity. As long as you haven't met your obligations under the contract, you cannot then use those assets for anything else. But of course, when I'm talking on behalf of the lender, then I'll push for that agenda, because that then secures the rights of the lender. So it's open. There's no limitation. You could, based on negotiation, have a continuing security interest, Or you could probably talk about creating a fresh security right, for subsequent loans. But what I know is provided for in the Act is that the issue of priority registration always takes precedence, so that so long as someone registers first, then that right always becomes, superior to any other person who comes after. So even if so long as you not met your liabilities for the first lender, you cannot then claim to deal with another person, at the detriment of the first right that you created. But as I said, it's negotiations. So what is in law is that there is priority of securities. First in time takes precedence. But if you want to do a continued security or fresh security, that of course is about how you negotiate, because the law doesn't prescribe it. The Act doesn't prescribe it as far as I know. Now, how long can a lender hold a movable asset, e.g., a motor vehicle, as per the Act? I think I may need to check, but I think it should be 12 years. Should be 12 years, but I may need to probably have another look, just to be sure. Yeah, 10 or 12 years, I would suppose. Yeah. If I have a business and register a trademark, is a trademark sufficient? If I have a business and register a trademark, is the trademark sufficient for me to trade, or must I also register a business name besides the trademark? Now, I have seen cases where trademarks, can't suffice, so long as you have an entity. You have an entity that houses your trademark. Then sometimes I see people just, going to the market with a business, as registered, and with a trademark, as a symbol that accompanies the business. But sometimes, of course, I also see other people going the direction of, you have an entity, or you have a business name, and then the trademark comes besides. So I think mostly when it comes to people who don't have like entities, people don't have like companies, partnerships, that is where sometimes they have to go the route of having a business name, and then the trademark now comes alongside as support to the entity. So I think I will say it depends on the structure or the corporate vehicle you're using. So if you're using a company, you're using, you're using all these structures like partnerships and CLGs, then the company itself is already an entity. So the trademark is just sufficient to help you go out of the business. But now if you're a sole proprietor, then you may need a business name, so that then you have that brand that attaches with the business name to help you going out to the market. Yeah.
Yeah, thank you, and I think you should also mention that advocates, some of them help people in that negotiation when you are negotiating for your stake and what is possible on your end, the value and things like that.
Very true.
That's where advocates come in.
Very
Now, I
true.
wanted to ask, there is a question there also, but I wanted to ask, is it a good idea to, I know enough of us MSMEs will wait until they have a need for funding, then they will look for registration. Is it a good idea to wait for that, or you start having these things secure first, then one day when you need security, then you might find an opportunity to pull them off? Yeah.
Yeah. I think, as a prudent businessman, you don't want to wait until trouble knocks. Then you start making frantic moves of trying to salvage your business. It's always good that you have everything in place. So register your trademarks, IP rights, register your copyrights, everything, so that when the need arises, then you don't have the burden of starting from going to the point of registration first before then you go to negotiate. So it's always easy for you to have the rights in place. You may pay some little fees when it comes to renewal of licenses and renewal of the marks, but it's a long time. So by the time that gets, probably you should have used it to generate money that can help you with running the right and keeping it active. Yeah. So it's always good to take the step of caution, be prudent, and get your house in order first before trouble notes. Yeah.
Thank you. Now there is a question from Dudsley. I think that's the right name. Or Dudsley, I don't know. What is the fee for getting an initial notice? And then the other one is BRS efficient? I think this is that online platform. On eCitizen. Is the BRS efficient in terms of covering fraudulent registration of movables, which maybe they don't rightfully belong to the grantor? Or I heard you talking of grantor. I don't know if you get that question. You can
Yeah.
comment on that.
Okay. Yeah. I think when it comes to efficiency of the BRS, I mean, we may not give it, they may not score 100%, but I think they do well. They do well. They do well in terms of uh, helping us to have these registrations. They're very efficient. Sometimes you have instant registration because it's something that is done online, so you don't have a problem. And because in terms of trying to take care of who is the rightful owner of the right, I think they also do some bit of DD. If you're the owner of the right, they need to prove that you are the owner. So if you are like a copyright owner, you need to show the certificate. Or if you are, and as I know under a contract, they need to show that you have an agreement with the owner of that IP right to be able to register. So I think they do quite a bit of that, and they help, with trying to ensure that the right person gets the right benefits for the invention. And I think for the fee for initial notice, I think there's a fee schedule that is on the BRS portal. If you get to it, then I think you may get to see it. But as far as I remember, the searches, you may only be charged for doing a search. But when it comes to registration, maybe lodging the initial notices, you may just incur the cost that goes with doing the registration, the searches, and of course, the convenience fee should be a nominal figure of not more than 1,000 shillings. Yeah, should not be more than, should be between 700 shillings to 1,000 shillings. And then when you do now the registration, I don't think there's a fee that is payable at that point. Yeah.
Thank you very much. Thank you very much, Brian. You can put your contacts in the chat for anyone who would like further consultations on the same. And all of us have learned that we each may be able to create some asset by starting to register something, having some entity, putting up these patents and intellectual properties, registering some name. And in that case, you may start growing your asset base invisibly. And the beauty is, if it's registered well, then it can't be stolen. Yeah, the other ones can be stolen. You can be robbed at night and it goes. So I'll call Odhiambola Ale to give a vote of thanks on our behalf, and then we move on. Thank you.